I'm going to have a seat. All right, does the defense wish to present a case?
Yes, Your Honor. May it please the court?
All right, you may call your first witness.
I would like to call Mr. Lawrence Dority.
Mr. Dority, if you'll make your way over to the witness box for me, please.
Does somebody swear or affirm to tell the truth, all the truth, and nothing but the truth, so help you God?
All right, just have a seat. And state your full name and spell your first and your last name for the court reporter.
My name is Lawrence Dority.
Spell the first name and the last name.
Lawrence, Lawrence. Last name Dority, Dority.
Mr. Thompson, you may inquire.
Mr. Dority, how old are you?
I am 32.
You have any children?
Yes, I have 3.
What are their ages?
13, 8, and 2.
What do you do for a living?
I am a barber.
Have you lived in Orange County all your life?
Yes, sir.
Are you married?
I'm engaged.
I'm sorry?
Engaged.
Let's get right into it. Switch gears a little bit. You obviously been here and sat through this trial so far. You've heard a lot of things. And you actually live in this situation. You recall what happened on May 9th, 2022?
Yes, I do.
Did you explain to the court and the jury what happened?
Well, around 1:30 in the morning, me, my son, and my dad went to my house. My father was taking me and my son home. And as we arrived, I see the car parked at the corner of my home, and I automatically assumed it was Terra. So I thought it was weird that she was parked right there, because she would typically park in the driveway or in front of the house. And so I walk over there to greet her, to say, hey, why are you parked here? And Mr. Payne gets out of the car. And when he gets out of the car, he's looking down at me. He has his hand in his waistband, and I can see like something silver sticking out on the side of his hip with his hand on it. And I asked him, what are you doing here? And he said, I'm not playing with you, I'll smoke you. I said, what? I threw my hands in the air and I started freaking out. My dad rolls down the window and asked me, is everything okay? And I told him, I don't know. So I go inside of my home. I retrieve my firearm so I could safely get my son in the house. And so as I return back outside, I see Mr. Payne has moved his car up even more, and he's gotten out of his car again. And so I'm standing in my driveway and I'm asking him, why are you here? What are you doing here? Why are you here? Can you please leave? Can you please leave? And he's just staring at me.
Okay. How tall are you, Mr. Dority?
5'8",
How much do you weigh?
145 pounds.
Did you have a relationship with Mr. Payne? Had he ever been to your home before? Did you invite him? I need you to make an audible.
No, sir.
Did you have a relationship with him at all?
No, sir.
Did you invite him to your home? I'm sorry?
No, sir.
Out of all the years that you knew Miss Terra Walker, had you ever actually met Mr. Payne?
Like twice.
Was there any situation where you guys had a issue?
No. I just seen him one time. He showed up to my girlfriend's mother's Thanksgiving or something like that. He showed up unannounced, and I don't even recall the other time.
So getting back to May 9, 2022, when you came, why did you go back in the house? Why did you go in the house?
Because I thought was gonna die.
Why'd you feel that way, though?
He's outside my house. He's telling me he's gonna smoke me. I have my son outside. I have my father outside. He's there by himself. Nobody, I didn't.
How many shots did you fire? A moment.
I try to go home.
Mr. Dority, when you speak into the microphone, let's just slow down a little bit. Let's try to take your time and make sure you speak into the microphone, okay?
What was the question?
At some point, you felt you went in the home and obtained your firearm. What were you thinking at that time?
I have to get my son safe. I didn't know. I just thought he was gonna kill me and my son and my father, and I didn't know. I didn't know what was gonna happen.
When you came back outside, and you had this firearm. First of all, did you have a concealed weapon permit?
Yes, sir.
So had you taken self-defense classes before?
Yes, sir.
When you came out, did you have any additional words or anything was said by you at that time?
Yes.
What was that, if anything?
I said, "Can you please leave? Why are you here? Can you please leave? What are you here for?"
And what was the response that you got?
He didn't say anything. He was just staring at me.
And then at some point, you felt the need to discharge your weapon. How many shots did you take?
One. I saw him. I was saying, "Why are you here? You need to leave. You need to leave. You need to leave. Why are you here?"
How were you saying it? Were you saying it softly, or how did you say it?
Like, "Why are you here? What are you here for?"
Were you talking to him?
I don't know.
Could he hear you?
Yes,
How do you know he could hear you?
because he was staring at me, and it wasn't far. It's like from here to the end of the courtroom. Like, it wasn't far.
When you came out the house, or at the time when you took a shot?
I mean, I was in my driveway the whole time.
Did Mr. Payne appear to reach for something, or
Yes. When I was saying, "Why are you here? You need to leave. You need to leave. Why are you here?" I seen him going like this, pulling his hand up, like he's raising a gun towards me. And I shot one time, and I called the police, and I put my son in the house.
before we get to that point, at some point, you stated when you went in the house and came back out that his vehicle was even closer than it was at first when you first encountered him. Is that true? Is that a yes?
Yes, sir.
So after the fire, after you discharged your weapon, you called 911? I need you to speak into the microphone.
Yes, sir.
Did you remain at the scene?
Yes, sir.
Did you cooperate with law enforcement?
Yes, I did.
Did you provide a statement to law enforcement?
Yes, I did.
Even after they give you Miranda warnings, you gave a statement, right?
I was never read any Miranda rights.
You provided a statement, right?
Yes, I did.
Is there anything else you want the jury to know that you hadn't said?
got up here, I thought I knew what to say exactly, you know, but I don't. It's just no.
I don't think I asked you this, but at that time, how old was your father?
60, 62,
And how old was your son at that time?
9,
How old? I'm sorry.
8 or 9, 8.
Were you intoxicated?
No. I was with the police for 13 hours.
None of the officers assumed or speculated that you were intoxicated?
No.
Now, at the scene of this incident, Terra Walker was present, right?
Yes, sir. Afterwards.
Did you see her go into the vehicle that Mr. Payne was in?
While I was on the phone with the police, I put my son in the house. I'm on the phone with the police. And I saw my father go over to Mr. Payne to see if everything was okay. And I can hear him telling her, find a piece of plastic so I could try to stop the bleeding. And I see her go through the back seat. She goes through both of the back seats. She goes through the front seat. She goes to the glove compartment, and she just runs. She runs to the other side, and we didn't see Terra until the police arrived.
Do you know, or did you see anyone else that may have had any relationship or affiliation with Terra Walker arriving on the scene?
Yeah, her brother and her father came, and I was just so confused because they had my son and my father and me like chambered away, and she's just frolicking around, calling her friends and
Objection,
calling her
non-responsive.
family.
Sustained.
You know, and I was just confused.
Mr. Dority, I'm going to ask you this question. Did you see a firearm in the hand or in the possession of Mr.
Yes,
Did you feel like your life was in danger?
yes, me, my son, and my father.
No further questions, gentlemen.
Cross.
Good afternoon, Mr. Dority.
Mr. Smith.
So, I want to go back to several things that you said in your direct testimony, but first I want to start out with, you said in your direct examination testimony that you gave a statement to law enforcement after this, right? Is that correct?
Yes, sir.
And you say in your testimony to this jury that you were never read your Miranda rights. Is that right? That's what you just said to your attorney?
From what I can recall.
Well, you didn't say you didn't recall, right? What you said to your attorney was that you were never read your Miranda rights. Is that right?
Yes, I did.
Okay. I'm going to direct you to page 12 of the transcript of your statement that you, with the detective in this case, beginning at line 5.
Really quick, can I say something?
I'm going to approach and I'm going to show you what I'm talking about.
Okay.
I've got to lay this for the record.
Okay.
Okay? I'm going to show your attorney. Permission to approach?
You may.
I'm going to let you read along. So this is where I'm reading from, but I'm going said
This is
something.
the interview?
Yes, this is the interview.
Okay. I was in response. I was talking about when they initially arrived to my home.
Okay. But just to
Not
be
this.
clear, what this says is, okay, well, let me do this. I want to read your rights, okay? And you say, and the detective says, and then we can talk about that after, okay? And you say, okay, buddy. And then detective says, so you have the right to remain silent. You say, and then anything you say can be used against you as evidence. Yes, sir. You're entitled to talk to an attorney now and have him present now or any time during question. Do you understand? Yes, sir. If you cannot afford an attorney, you can be provided with one without cost. Do you understand your rights? And then you said, after being read that, in the transcript of your interview with the detective, yes, sir. So you were read your Miranda rights, correct?
Yes, I was not read them initially when I was placed in handcuffs, which I was referencing to,
Okay.
not my interview.
Your testimony to this jury not 10 minutes ago was that you were never read your Miranda rights. Is that correct? Never. That's what you said. That's not true, is it?
I was read my Miranda rights in the interview room.
Okay. Thank you. Now, another thing that you just said that I found to be interesting is you said that when you came back out of your house, after you'd gone in the house and armed yourself with a firearm, you said that you came back out and you said, can you please leave? And you were speaking sort of calmly to the jury in a sort of meek tone that you're speaking today. Can you please leave? And this is after you came back out, after you armed yourself with a firearm, you're asking him, can you please leave? Is that right?
Correct.
Okay. Well, I want to direct you. I'll let you look at it. I'm going to read it again. I'm going to tell your attorney to, this is your interview with Detective Gilberti. This is on page 50, beginning at line 16. This is going to be line 16 through line 23. Permission to approach.
You may.
I'll let you look at this and then I'm going to read it out loud because this is the opposite of what you just said. Starting in line 16, I'll give you a moment to read through line 23. All right, so your testimony on direct examination was that you were just asking him to please leave when you came out with the firearm, right?
Correct.
Okay. But what you said to the detective in your interview was, and I'll begin on line 16, a detective, like when you came back out with the gun and he was still in his car.
Best evidence, Your Honor.
Response?
This is impeachment.
Overruled.
Like when you came back out with the gun and he was still in his car, did he say anything to you? No. Well, sorry, Mr. Dority, your response was no. The detective says, was there any communication? And Mr. Dority, your response was, I didn't communicate with him, I shot him. That's what you told law enforcement the day that this happened in your interview, right? You didn't say, could you please leave? You just shot him. Is that right?
That's what I had said in the interview.
Right. Okay. So I want to go back a little bit. This afternoon, the afternoon going into the early morning that this shooting happened, you were at your father's house, right?
Correct.
And you had been drinking at your father's house?
Earlier that day.
And you had been drinking some shots of Casamigos at one point in the afternoon, right?
Earlier that day.
Okay, but earlier that day, you had been drinking shots of Casamigos, correct?
Correct.
Overruled.
Earlier that day, you had been drinking shots of Casamigos, correct?
Correct.
Okay. And to be clear, where was your vehicle when when you came back to your house?
Parked in my driveway.
Okay. And so your father drove you to your residence from his house, right?
Correct.
But it's a close distance, right?
Yeah, I could have walked.
Okay. All right. So I want to talk about some other things that you said in your direct testimony. You were very clear in your testimony 5-10 minutes ago when your attorney asked you, did you see a firearm, right? You said, yes, I saw a firearm. That was your testimony 10 minutes ago, right? Correct?
Correct.
Okay. Now, I want to take you again to your interview with the detective in this case. This time I want to direct you to page 35 of the transcript of the interview. Now, on page 35, do you have the transcript or do you need to see it?
I have a copy of it, but I don't know exactly.
Sure. I'm on 35 at line 25 and 36 at line 3. All right, so Mr. Dority, I'm going to read from this transcript starting at line 25 on page 35. Detective Gilberti, this is his question to you. Okay, did you ever see a gun? Mr. Dority, I cannot say I necessarily saw a gun, but if you're giving me this gesture, I've taken concealed weapons classes. I've taken defense classes before. If somebody approaches me like this, and that's your answer. So you cannot definitively say and honestly say to this jury,
Objection, Your Honor. Objection, Your Honor. Argumentative.
Sustained.
you cannot say definitively that you saw a gun, can you?
Objection, Your Honor. Same objection. Argumentative.
Sustained.
Judge, can we approach?
Come on.
So today in your testimony, you mentioned that you saw a shiny object when you first approached the victim's vehicle, right?
Yes.
Is that correct?
Correct.
Okay. But you never said anything at all in your initial interview with law enforcement about seeing this
Objection,
shiny
improper
object.
impeachment.
Overruled.
You never said anything at all about the shiny object then, right?
When
When you had your interview with law enforcement at the interview room.
I had been waiting and sitting in the back of a police car for 7-8 hours. I was in the interview room for 6-7 hours. I hadn't slept. I was beyond tired, and my recollection of what happened could have been maybe, I don't.
Okay, so you didn't say it then, but you're saying it now, right?
I said it.
Okay. Now, you mentioned in your direct testimony that you were concerned for your son and for your father who were present at the time of the shooting, right? Is that yes?
Yes, sir.
Okay.
I apologize.
But even by your own telling, there was never any threat by the victim made to your son, right?
Objection, argumentative, Your Honor.
Overruled.
There was never any threat made by the victim to your son, right?
Correct.
Is that correct?
I said correct.
And there was never any threat made by the victim to your father, right?
Correct. It doesn't have to be made to them, though.
Okay. Now, you would also agree that where the victim was parked was not your property, right?
The neighborhood is considered my property. I don't own the neighborhood, but it's my dwelling. That's where I live.
Okay. But to be clear, Mr. Payne never set foot in your house, right?
No,
He never stepped foot on that piece of grass in front of your house.
he may have.
Okay. Do you remember a previous testimony in a hearing? In a courtroom like this?
Yes.
Okay. I am going to direct and show opposing counsel transcript of a previous hearing.
I don't know what he did when I went in the house.
Okay, I'll direct a question to you in a moment. Showing opposing counsel the transcript, page 156. Okay, so my question was, at the time, was that area that he parked, is that your property?
No, sir.
Okay, so you're saying it was not your property. You agree?
It wasn't my. I don't own the land. I don't own it. I was a tenant there.
I understand that. But you leased the property, presumably?
Yes, sir.
Okay. And with that lease, it doesn't entitle you to the entire neighborhood, correct?
It's a private neighborhood.
It's a private, is there a gate to get in?
There was until it was destroyed.
Okay, so at the time of this, you could just drive into the neighborhood, correct?
Yes, you could.
Okay.
It's still a private
And
residence.
that area that the victim was parked, that's not included in your lease, correct?
Correct.
Now, when you went inside your home to arm yourself with a firearm, in this case, the victim didn't follow you, right?
No.
He stayed by his car.
Correct.
And so you went in, you would have had time at that point to call 911 if you deemed it necessary,
Correct.
but you didn't do that, did you? Did you?
I didn't think it was necessary at that moment.
Okay. What you deemed was necessary was to get your firearm, you go outside, and kill it, right?
No.
But that's what you did.
It's not subsequently what happened.
So you went in the house, right?
Correct.
You armed yourself with a firearm.
Correct.
You went back outside the house.
Correct.
You aimed. Before you shot, you aimed. Yes?
Correct.
And then you shot Adrien Payne.
After I asked him to leave several times.
And again, we already went through your original transcript, but what you previously said was you didn't communicate with him, you shot him.
You have
right?
audio recording of it.
Okay. I'm asking the questions here. You said, in what we've already established in your previous transcript, you didn't communicate with him, you shot him, correct?
If you say so.
I mean, we can look at it again. Do you need to look at it?
No, I looked
Transcript
at it
of
already. You already showed me.
Okay, so you would agree. You said you did not communicate with him, you shot him, right?
Correct.
All right. I don't have any other questions. Thank you.
Redirect.
Yes, briefly, Your Honor.
Hello.
Your interviews with law enforcement was recorded, right?
Correct.
Okay. So your conversation that you had with law enforcement that spanned over several hours could be shown to the jury, couldn't it?
Yes, sir.
Okay. At the time when I asked you, had you been given Miranda warnings, is it your testimony that you thought when you were first encountering law enforcement, they never asked you a question as far as Miranda?
Correct.
But at some point throughout the time that you were in custody, You were at some point in the interview provided with Miranda warnings?
Yes, and I feel like, he tried to trick me with that question, which is how the answer came out like that.
Okay. And again, you seen a video of outside, right?
Correct.
Could you hear the verbal altercation that you had with Mr. Payne?
Yes.
So you did, in fact, communicate
Yes,
to
I did.
Mr. Payne. Okay. In fact, you heard the testimony of Ms. Terra Walker, too, today, right?
Correct.
She also testified that you asked, why are you here, right?
Correct.
So you did communicate.
Correct.
Is it that you was probably confused when law enforcement was questioning you, possibly?
Yes.
Okay.
I was beyond exhausted. I was tired. I could barely keep my eyes open. It was like 10 o'clock the next day. I hadn't slept.
And again, that interview was recorded, right?
Correct.
Video recorded?
Yes, sir.
No further questions, Your Honor.
All right, sir, you can have a seat back at council's table. All right, defense, call your next witness.
Your Honor, defense rests.
State wish to present any rebuttal evidence?
No, Your Honor.
So state rests.
State rest.
All right, let me have counsel approach. All right, ladies and gentlemen, the state and the defense have both rested their cases at this point. There are some other legal matters that I need to take up outside of your presence, and then we will have to be working on the charge conference, which is the jury instructions that will be sent to you and the verdict forms that will be sent to you. And so what I'm going to do is, while we work on that, the remainder of this afternoon, I'm going to send you all home a little early, okay? When you come back tomorrow, we will have those instructions ready. There will be copies and everything ready for you all, and so that we will be ready to go when you get here. At that point, I will give you all the closing argument instruction. The attorneys will make their closing arguments to you, and prior to lunch, you will then be out to deliberate. What I will ask for you all to do tonight before you leave is I'll have the court deputies give you the lunch menu for tomorrow. Make a choice of what it is that you would like for lunch so they have it, so they can order it so that it'll be available in the jury room for you around 11:45 noon tomorrow by the time you get back there or when you're out there, back there deliberating, okay? Also, make sure you get the number from the sheriff's deputies before you leave so that you can share that with your loved ones or family members who may need to get a hold of you, because you can expect that sometime mid to late morning you will be in the jury room deliberating the verdict in this case, okay? Any questions before we break for the night? All right. Same rules apply. Obviously, please don't do any investigation, any looking up of anything on your own. And I'll ask you all to come back tomorrow morning at 9 o'clock, okay? I only have one thing else on my docket in the morning. It's a very brief matter, and I will have that done relatively shortly, so we should be able to get started right away, okay? So I will make sure you get the menus for them. Once you get the menus, go home for the night. We'll see you back tomorrow at 9, okay?
That's for me.
All right, go ahead and have a seat. All right, the close of all the evidence, any motions or matters that I need to address from either party?
Oh, yes, Your Honor. I would like to renew my motion for judgment of acquittal as it relates to the issue of, I don't believe the state has rebutted the defense's claim of self-defense. And so I would like to state, just as a matter of course, in viewing the facts of the case in the light most favorable to the state, they have failed to, like, once the defendant introduces any evidence of self-defense, the state bears the burden of proving beyond a reasonable doubt that the defendant did not act in self-defense. And that's Bozeman v. State, 714 Southern 2nd, 570, Florida First DCA case in 1998. And it's on point here. The state didn't provide any rebuttal evidence in regards to a claim of self-defense, so we would argue that at this point, the judgment of acquittal would be warranted, at least as it relates to elements of second-degree murder with a firearm. I do understand that this is a factual issue that is usually more properly presented before a jury, but pursuant to Martinez v. State, 981 Southern 2nd 449, a Florida Supreme Court case of 2008, if the state fails to carry this burden of rebuttal in regards to not proving beyond a reasonable doubt that the defendant did not act in self-defense, the defendant is entitled to a judgment of acquittal. It even goes so far as to a Florida Supreme Court case of 1974, Lynch v. State 293 Southern 2nd 44, to defeat a judgment of acquittal in a self-defense case, the state must present evidence from which a reasonable jury could conclude that the defendant was not in reasonable fear of imminent harm, or the force used was not necessary or was excessive, or the defendant was the aggressor, or the defendant was looking to retreat. The judgment of acquittal must be granted if the defendant presented a plausible case of self-defense and the state fails to rebut it with competent, substantial evidence. That's what we have here, Your Honor. Mr. Dority is charged with second-degree murder with a firearm. The defendant has presented credible evidence that the defendant acted in lawful self-defense pursuant to Florida Statute Section 776.012 and or 776.013. Under Florida law, once a defendant introduces any evidence of self-defense, the burden shifts to the state of Florida to prove beyond a reasonable doubt that the defendant did not act in self-defense. So with that being said, when viewing the evidence in the light most favorable to the state, they fail to provide competent or substantial evidence from which a reasonable jury could find that the defendant was not in reasonable fear of imminent bodily harm, that the defendant's use of force was unnecessary or excessive, or the defendant was the initial aggressor, or the defendant had a legal duty to retreat and failed to do so. In this situation, therefore, no reasonable jury could lawfully reject the defendant's theory of self-defense and still find beyond a reasonable doubt him guilty. As such, pursuant to Lynch v. State, the state has failed to meet its burden under the applicable standard of law, case law precedent, and therefore judgment of acquittal is proper. Thank you.
Judge, I think there's a misconception. Obviously, just because the defendant testified doesn't mean that I have to then put on a rebuttal case, which is sort of what it sounded like opposing counsel was saying. Obviously, the defendant's story is rebutted by the evidence that was already placed on by the state, particularly Terra Walker and the video that was presented into evidence where you can hear the encounter just before the shooting and the shooting itself. She stated that the defendant, came out and that he fired, not having been, there was no threats made in his direction, that the victim didn't have a weapon, there was no weapon found in the vehicle. All of this, a jury could find beyond a reasonable doubt that he did not act in self-defense. Further, by the defendant's own admissions in his statement, just because the defendant says it's self-defense doesn't mean it is. So while he characterized what he did on that day as self-defense, it certainly wasn't. If you look at the applicable law and the instructions that you're going to give the jury, that it has to be reasonable, and it's both an objective and a subjective standard. So the defendant himself has to reasonably believe that his actions were justified and necessary in the circumstance, and even if you found that that was met, objectively, a reasonably prudent and cautious person in the same or similar circumstances would have to feel the same. And his actions of going back in a house, arming himself, coming back and shooting somebody, that is not justified. That's not self-defense. So even if you just took his own words, he's not rebut the state's case that he was not acting in self-defense in this circumstance. I would point to, obviously, just going to the other point regarding the JOA, I'd point to Mackey versus State, the first district case, 277 Southern 3rd, 762. I say it's a depraved mind, regardless of human life, second-degree murder may be established by competent, substantial evidence that the defendant acted with ill will, hate, and spite, and that the circumstances surrounding the fatal act can prove the ill will, hate, or spite. In this case, you have the circumstances around it that show it. You don't have to have an express testimony or express statement that there was malice or evil intent, spite. You can look at the circumstances as we have here, and we can clearly see that this defendant was not acting in self-defense. So I ask that you deny the JOA.
Your Honor, and briefly, I'll just add, these facts supports the judgment of acquittal. 1:30 in the morning, size difference, uninvited. You can infer that Mr. Payne wasn't coming over to wish him happy birthday. Okay? Again, had no relationship with Mr. Dority. His girlfriend told him not to come. Despite doing that, he still came. Even after Mr. Dority went into the house, just think about that for a second. If someone is objectively questioning why you're present at a certain hour at someone's home, place of residence, your castle, no, he's not inside the home, but he's lying in wait as he comes home. Very close proximity to where he lays his head, where his child lays his head. His father is in his 60s. His son is 9 years old. He's questioning why you're here. And the threat of posturing yourself as if you have a right to be at someone's home without an explanation, that placed Mr. Dority in fear. And if Mr. Payne didn't want any problems, if he didn't want any smoke, any issues to occur, when Mr. Dority retreated into his home, because he didn't just walk up to him with a firearm. He didn't walk up to him wanting a confrontation. He thought it was Terra Walker in that vehicle. She had been driving that vehicle for several months. Unknown to him, it was someone else who rolled the window down, hopped out the car, and surprise, this is not what you want, little man. Yes, it is an issue of what was said. Nobody in this room was there other than Mr. Dority and Mr. Payne. Terra Walker wants you to believe that she was there when it initiated. She was not. She admitted he was already there. She claims to have been on the phone with him and heard some chatter, but she can't say conclusively what was said. But if you didn't want any problems, reasonable people would acknowledge the fact that when someone goes into their home and you are now on notice that you are not wanted there, he could have left. But instead of him doing that, what did he do? With his 6'8" frame, 247 pounds, he moves up closer to the man's driveway. That places somebody in fear at 1:30 in the morning. Coming home and somebody you don't have a relationship with waiting on you, and you ask them why you're there. By the time you go in that house, he needs to be gone when you come back outside. That didn't happen here. This is common sense. The way the legislature works with these gun laws, this is not like a random shooting that happened in New York, just shooting bystanders. Even Governor DeSantis is pro-guns. He removed the need to have a concealed weapon permit. For situations like this, he's at his home. Asked him to leave. Even Terra would agree. He asked, why are you here? All this chatter about you told law enforcement you didn't communicate. The video itself shows there was communication going on. Terra herself said that it was communication going on. Whether he was giving Miranda or not doesn't matter. He gave a statement. So that don't even matter. Your Honor. At the very least, before we let this get to the jury, if you find that it needs to get to that point, which I submit to you, you should not. But if you find it that it's necessary to let the jury deliberate, they should not be deliberating over second-degree murder with a firearm. That is an overcharge. That is not what we have here, by any stretch of the imagination. Not that. Maybe negligent homicide, maybe. Something definitely lesser than second degree should go to this jury. Not second degree murder. He shouldn't be facing life for that. That's not what the people of Florida support. The public would not be...
Judge, I'm going to object to the improper argument talking about what the people of Florida would support.
Staying, let's confine our argument to the facts and what the standard is for a judgment of acquittal at the close of the case.
I have nothing else, Your Honor.
All right. Based upon the evidence that's been presented to the court and the standard that applies at the close of all the evidence, the court does find that there is sufficient evidence to allow the case to continue to the jury, so the judgment of acquittal will be denied. Counsel for the state provided a copy of, or a draft of verdict forms and a draft of jury instructions to the court. Mr. Thompson, did you get a copy of those?
Yes, Your Honor, I did.
All right. And did you have a chance to review them with your client?
Not thoroughly with my client, I did not.
Do you have a copy of them on your computer that you can pull up?
I do.
Okay.
Oh, yes, Your Honor, I did send this to him.
Okay.
We discussed.
All right. Mr. Dority, did you get a copy of that was sent to you by your lawyer?
Yes, Your Honor.
Was that a yes?
Yes, sir.
Okay. And did you have a chance to read through it?
Yes, Your Honor.
And did you and your attorney have a chance to discuss it?
Yes.
Okay. What I'm going to do is you have a copy of it now up, Mr. Thompson, so you and your client can see it?
Yes, Your Honor.
State, have yours up?
Yes, Your Honor.
Okay. So we'll just kind of go through it. I assume nobody has any objection to the caption?
No objection.
No objection from the state.
All right. And then there's the standard instruction on final instruction or introduction to final instructions. Anybody have any objection to that?
No objection, Your Honor.
No objection.
All right. The next standard instruction has to do with the statement of the charge. Any objection?
No, Your Honor.
No, Your Honor.
Next instruction is the introduction to homicide instruction. Any objections?
No from the
No
state.
objection.
All right. The next one is justifiable homicide instruction. Any objection?
I don't have that in that order. So my page 5, it goes from excusable homicide and then into second-degree murder on page 6.
Well, the one you sent me had an introduction to homicide instruction, then a justifiable homicide. It's probably part of the introduction to homicide.
Okay,
If you go down
Yes,
in
okay.
there,
I see, yes.
I break it out as a separate instruction.
Okay.
I have the same thing.
Okay, so, but it's part of the introduction to homicide, but it's a separate little subsection that says justifiable homicide.
Understood.
Nobody has any objection to that.
No objection, Your Honor.
No from the state.
And then right under that is another subsection for excusable homicide. Any objection to that?
No objection.
No from the state.
All right, and then the next instruction is the second-degree murder instruction. Take a look at that. Tell me if anybody has any objections to the second-degree murder instruction.
No objection other than what's previously been argued. Yeah.
I understand that you're reserving your right on the judgment of acquittal.
No objection from the state.
All right, and then the next instruction is the standard instruction on aggravation of a felony by carrying a firearm. Any objections?
No objection, Your Honor.
No objection from the state.
Next one is the standard instruction on possession of a firearm, discharge, and causing death.
No objection.
None from the state.
All right, the next one is the standard instruction on when there are lesser included crimes.
No objection.
No objection from the state.
All right, and then the lesser included crime is defined as manslaughter. Any objection to that instruction?
No objection.
No objection from the state.
All right, and then there is a repeat of the aggravation of a felony by carrying a firearm as it relates to the manslaughter. Any objection to that instruction?
No objection.
State.
No objection from the state.
All right, and then there's the justifiable use or threatened use of deadly force instruction. Take a look at that.
I have this highlighted. I don't know, there's different language, and the defense has to affirmatively state what, if they're seeking the part B, which I put in as aggravated assault, just based on prior arguments that they had made at the stand your ground hearing. That would sort of be my anticipation of what they would be asking for regarding the forcible felony. But if that's not what they're asking for, obviously we'll need to go in and, change that.
That's why I'm asking the defense to take a look at it and see if they have an objection or if they're asking for any changes.
No objection, Your Honor.
Okay. I assume the state has no objection.
No objection.
All right, then we get to the standard instruction on plea of not guilty, reasonable doubt, and burden of proof. Any objection to that?
None from the state.
No, it looks standard. No objection, Your Honor.
Let me get to the standard weighing the evidence instruction. Paragraphs 1 through 5 were included, and then I added the sixth, or there is a sixth paragraph added that included making inconsistent statements in court. Does anybody believe that the other 4 paragraphs apply? I don't think that they do, but
I believe the 6 that we have are appropriate.
defense?
I agree, Your Honor. I don't see what the other ones were. That's all I received. I didn't receive the other ones.
Well, the other ones usually have to do with reputation and for dishonesty, criminal convictions. None of that kind of stuff came out.
I have no objection.
All right. And then the next standard instruction is the defendant's statement instruction.
I think it's missing the caption, I think, maybe, at the top.
Where it says defendant's statement.
Yes, Your Honor.
I have it on my copy.
I don't have it on mine. Well, I have it. The next page has it.
All right, there, you got it. Any objection to that instruction from either party?
Not from the state.
No objection, Your Honor.
Okay, that gets us to the rules for deliberation, standard instruction. Any objections?
None from the state.
None from defense.
All right, and then the standard instruction for cautionary instruction, any objection?
None from the state.
None from defense.
Standard instruction on verdict, any objections?
None from the state.
No objection.
And then the standard instruction on submitting the case to the jury. Any objections?
None from the state.
No objection from defense.
All right. And Mr. Dority, you've had a chance to go over this as we've gone through it here in court. You had a chance to go over it previously with your attorney. Is that correct?
Yes.
All right. And you agree with the choice of lesser included offense for being manslaughter?
Yes.
Okay. And are you in agreement with the instructions as your attorney has indicated?
Yes.
And then for purposes of closing, I assume, counsel, you're going to again concede elements of the offense or the lesser included offense, but as part of your self-defense claim?
Yes, Your Honor.
All right. And so, Mr. Dority, as you indicated to me previously, you understand that that's the strategy that you and your attorney have agreed upon for purposes of this case? All right. So you understand that during the closing argument, as he did during the opening argument, he may be making concessions that the shooting happened, but his claim is that it was self-defense. You understand that? And you're in agreement with that strategy?
Yes, sir.
All right, so the verdict forms then are finalized. I will have my assistant make multiple copies. I'll make 2 for you all, so you all each will have a hard copy. I'll make a copy for the state. Rebecca, do you need one? All right. I'll make 1 for the clerk, so that's 4. And then we need 8 for the jurors, so I'll make a total of 13 so that I have 1 to read from. I'll make those copies. I will make sure that I have them all here. We'll disseminate them for the jurors in the morning, and I'll have copies for you all ready when we come into court, okay?
Thank you, Your Honor.
All right, so, and then as far as the jury verdicts go, you got a copy of those, Mr. Thompson?
Yes, Your Honor, I do.
All right, and you forwarded that to Mr. Dority as well?
Yes, Your Honor, I do.
All right, Mr. Dority, did you get a chance to look at the verdict forms? Okay. All right, the verdict form as to count 1 gives the jury 3 options: second-degree murder, the lesser included offense of manslaughter, and not guilty. Any objections to that verdict form?
None from the state.
No objection from defense.
And then there are 4 special findings based on the way that the case was charged. The first special finding has to do with possession of a firearm or no possession of a firearm. Any objection to that special finding?
None from the state.
No objection, Your Honor.
The second special finding has to do with discharge of a firearm or no discharge of a firearm. Any objection?
None from the state.
None from defense.
Third one has to do with discharge causing death or not causing death. Any objections?
None from the state.
None from defense.
And then the fourth special finding has to do with personally carrying, displaying, using, threatening to use, or attempting to use a firearm or not. Any objections?
None from the state.
No objection.
All right, so the verdict forms and special findings are in order, and I will have my assistant make 1 copy of those for the jurors. All right, anything else that I need to address from the state or defense before we adjourn for the evening?
Nothing else from the state. I know some judges have different, when you're saying what you're going to send back with them, the jury room, some judges will send everything back, some judges don't want to send the firearm back. I don't know what you were planning to do regarding the firearm and the defense out of position.
All right. I know that sometimes in the past they've done that where they've rendered them safe and sent them back, but if you all aren't comfortable doing that, then we'll send everything back with the exception of the firearm. I'll let the jury know if they want to see the firearm, that they can ask me with a note to see it.
Understood.
Okay?
Yes, Your Honor.
All right. Anything else from the state?
Nothing further from the state.
Any further from the defense?
Thank you.
All right, then we will be in recess on this case till 9 o'clock tomorrow morning.
Thank you, Your Honor.
All right.